Good morning, everybody. It's nice to see you all here, and it's nice to see some new speakers coming after difficult travels. I would like to talk about Russian case of implementation of the convention. I would like to, I hope I will be really brief. And honestly speaking, after Professor Omeid's presentation, I can't do anything to impress you. Actually, I have an advantage because Professor Omeid told me I have an amazing presentation, and I thought, okay, if Professor Omeid already has an amazing presentation, I should be pretty basic, and so my presentation is like 3 steps presentation. I will start with 2 examples from the Russian Constitutional Court case law. Then I turn to statistics on execution of the European Court of Human Rights judgments, and I will end with some thoughts on mechanisms of domestication of the European Convention. 2 examples, and it's again quite easy for me because it was mentioned yesterday. So the first example is the judgment of 19th of April of this year, where the Constitutional Court decided that, the Anchugov and Adlankov case, it's like the Schrodinger's cat. It cannot be implemented, but it's already implemented. But this is not what is important here for us. What is important is these 3 statements. The first statement is that there is no unconditional obligation to execute the European Court of Human Rights judgments. Secondly, the case is where there is a conflict, or at least where there is genuine conflict between the constitutional text and the obligations stemming from the judgment of the European Court of Human Rights. Well, the national constitution should prevail. And the third statement is that the harmonization of 2 legal orders, which of course the Constitutional Court of Russia respects, but it has its limits, and the limits are set by the constitutional identity, now we hear this concept again, and its manifestations in the Constitution. Now, I don't like the term of the constitutional identity, or maybe I don't like how it is used. I don't like the use of constitutional identity. It's a rubber concept, and who gets to decide what constitutional identity is? Definitely constitutional courts think they get to decide. And Russian Constitutional Court is also the court that says, well, we know better what our constitutional identity is there. That's why we think, European Court of Human Rights should respect our opinion on that. So this is the first case. And the second case is actually a more recent case of 15th of November of 2016, where the Constitutional Court actually struck down the law, or the provision of the law, that puts the ban on long-term family visits to life prisoners, by expressly and explicitly citing Poroshenko versus Russian judgment, where the European Court of Human Rights found the violation of the convention. So it's a clear implementation of the standard that the European Court of Human Rights put forward. So my question is, what decision is more important? So one may argue that the second one is actually more important than the first one. Why? Because the first one is clearly an exceptional case. So how many cases we may find where we have an clear conflict between the Constitution and the Convention, or the Convention as interpreted by the European Court? Well, 1, 2, maybe. More creative courts may find 3. Secondly, well, this case is all about prisoners' rights. Well, what is more important for the prisoner and for the prisoner's socialization? His or hers right, the elections right, or his or hers long-term visits? Well, one may argue the second. I'm not arguing that the second is more important, but if we think about it, maybe it is. And definitely for a particular prisoner, it's more important what happens within the prison than outside the prison. But my answer to the question is actually, I would say, neither of them is important. Why? Because extreme positions don't matter. And those are extreme positions, I think. What matters is what we call in Russia the average body temperature in the hospital. Okay? So usually, when Russians say the average body temperature in the hospital, they criticize the statistics. Okay, well, statistics doesn't tell us anything. It's like asking what's the average body temperature in the hospital, which is always fine. All right? Especially if you count the morgue, for example. So, but anyways, let me turn to statistics to prove my point. So this is Committee of Ministers statistics on execution for Russia. So we have a blue line, which is pending cases. And we see that, that at least, I took this 6 years period. 6 years, we see the drastic increase in pending cases. Now you ask why? Well, it's actually new cases are going down, which means that every year there is a decrease of the number of the cases coming to Committee of Ministers for the execution. So why is the growth? Well, it's because of the green line, and the green line is closed cases. So Russia closed in 2010 0 cases, 2011 7 cases, 2012 3, then 9, 3, and then you see 44. But still the increase is there. Now if we turn to the second slide, and I'm sorry to cite Turkey, but it seems that it's already an established tradition of this conference for other speakers, to kind of go forward and say, let's talk about Russia. Before we talk about Russia, let's talk about Turkey. But I'm not talking about Turkey. I'm just trying to show that there is indeed a correlation between closed cases and pending cases. You see that Turkey had pretty nice dynamics during at least 2012, 2013, 2014. Why? Well, because they closed more. They basically did most probably general individual measures better than Russia, at least. Okay? So this is the average temperature in the hospital that shows, well, the problem of Russia is not in excess cases, but in average approach to how Russia respects its obligation to execute the judgment of the European Court of Human Rights. Moreover, execution of judgment is not the only way of implementing the European Convention. And as Helen Keller and Alex Stone-Sweet say in their Europe of Rights book, there are certain mechanisms of what they call reception or domestication of the Convention. And apart from doctrinal factors, apart from incorporation and hierarchy of norms, and we were talking about these issues a lot already. So what is the place of the Convention in the legal system? What is the country's stance on the role of international law, whether it is dualistic or not? There are many other mechanisms that matter whether the European Convention serves as shadow constitution, and we see that in many countries like Croatia and Ukraine, it seems that European Convention plays this role. Well, in Russia, it's definitely not the case. So the case law of Russian Constitutional Court is in a way not misleading, but leading in different directions. It's going, well, we respect the convention, we respect the obligation to execute the judgment, but maybe not in all the cases. So there are very good examples, and there are very, very bad examples. But what I want to say is that not only bad examples, okay? Then legislative coordination mechanisms, when there is a unit, for example, in a legislature that checks whether new drafts are in compliance with the obligations. Now, this is a problem for Russia, because if we look at maybe last 3 more years, the Russian legislature creates a lot of laws that are, from the very beginning, are clearly against the obligations under the convention. And I think they do understand that they are against their obligations, but they still enact these laws. That is something which is telling. Judicial and other ex post mechanism of coordination. Well, for example, when you have the right to turn to Supreme Court after you get the judgment of the European Court of Human Rights that says, well, the Article 6 rights were violated, for example. And this mechanism is in the Russian legislature, and in Russian legislation, and it was the legislation was amended after the European Court of Human Rights suggested that it should be amended. So there is these implementation steps. Now, how the mechanisms is working is a completely different story, and it's definitely a matter of a completely separate analysis. And informal mechanisms, the knowledge and practice, they also matter a lot, and Professor De Londres yesterday were asking these questions about whether there is whether the curricula of universities include the human rights, European human rights as a subject, whether the trainings for members of the bar, for judiciary include this. I mean, it does include in Russia. Now, whether it makes difference on a ground level is a completely different story. For example, I do hear Justice Shevchuk when he says, well, in Ukraine, ordinary judges don't have really time to read this. Russian Supreme Court does the review of the cases against Russia and publishes this review on its website. It's accessible. It's very good, I must say. Now, without the pictures, I think we will suggest them Professor Mayetz as a consultant, and maybe things will change. But the thing is that this is done, but definitely the caseload of Russian judges is such that they cannot cite, or they cannot cite reasonably the European Court of Human Rights case law. Now, my last points. I mean, of course, I'm going with bullet points because I want to have some time for discussion. Well, domestic mechanisms in Russia show the lack of commitment towards the respect for human rights in general and European Court of Human Rights, European Convention in particular. Now, this is what is more important than this or that judgments of constitution. There is a clearly shown disregard towards Russia's international human rights obligation. This disregard is shown by both legislature and executive. And courts, actually 3 branches, and courts as well. Now, of course, I told that neither of those judgments were actually important. And of course, I lied a bit. Because I think, of course, the first one is very important. because the Russian Constitutional Court's power to declare the judgments of the European Court of Human Rights unenforceable does matter. It's an exceptional case. It's not, the Russian court is not saying, you know, when there is a problem between one standard that we have that might be higher and the other standard that the European Court of Human Rights has, which might be lower or different, we think that our standard should prevail, but in any case, we have to execute and enforce the judgment. But this is not what they're saying. What they're saying that we can disregard our international obligations. It's very important, especially in the context of the general disregard towards the international obligations. So it kind of sets the bottom line, which means that all other high points, like the judgment of November, the system doesn't really get these judgments as signals of something that mattered. They rather get the signal, oh, now it's actually not important to implement the European Court of Human Rights judgment. That's what we thought. That's actually what we do on a day-by-day basis. And now the Constitutional Court said, well, you can do that. Now, where the Constitutional Court, you know, here and there, now and then, decides that they should implement this or that judgment of the European Court of Human Rights doesn't really matter. Especially if it might be actually a matter of negotiation between Russia and Council of Europe. It's like, okay, yes, we did, you know, that there is that pronouncement that we can disregard your case law, but it's an exceptional case. Now look, in other cases which are reasonable, we are following your case law, so maybe you should just forget what we did with, you know, Anchugev and Gladkov, what we are going to do most probably with Yuka's case. So this is my conclusion, that of course the first judgment matters, but it matters only in the context of the general average low body temperature in Russian judiciary and legislation and executive. Thank you very much for your attention.